you know, it's easy in the law to take the simple path to just say, well, the law is what it is and I'll just work within it. But it's inspiring that he didn't. Where he saw injustice, he sought to change things, whether that be in the environment, in Aboriginal rights, wherever he saw disadvantage. And he went in boots and all.
My name is Andrew Lynch and I'm the Dean of the Faculty of Law and Justice at UNSW, and it's my great pleasure to welcome you to the 2024 Hal Wootten Lecture. In perhaps a non-traditional order, I really want to welcome all the students in our audience tonight. This lecture series was conceived of with students very much in mind, and this is your faculty, and you are the current members of a community created over 50 years ago with a distinctive purpose and bold aspirations. So it's really important and valued that you're here. Thank you. I also welcome all of you who are sitting alongside and amongst our students, my colleagues in the faculty and other academic guests, our alumni, including members of our dedicated Law Advisory Council who contribute and support our endeavours, distinguished guests, including the family of our speaker tonight, David Heilpern, and also Professor Gillian Carlishaw. Hal Wootten was Gillian's husband, and in fact he was much more memorably described to my mind as Jill's legal aid boyfriend by Frank Doolan, a senior Wiradjuri man who became a great friend to them both. And it's always really special to welcome Gillian back to this place, which began when Hal was appointed as Foundation Dean in 1969 and opened its doors to students in 1971. He declared the founding of the UNSW Law Faculty to be the part of his career that he found most satisfying and of which he was immensely proud. I also welcome Emeritus Professor David Dixon, who is going to deliver the vote of thanks after the formal lecture has finished. David was, of course, Dean of the faculty for a record term from 2006 to 2016, and he was my boss and the boss of many people in this room, and it's with great affection and respect that we welcome him back to speak tonight. I wanted to take a few minutes out to reflect on some words that David Dixon and I have been poring over from Hal's and to share those. In 1971, Hal Wootten wrote a letter to new students in that very first year of teaching. And amongst other things, he said the following: "We believe that law is not an end in itself. It is to be judged by the extent to which it promotes the well-being of the people living in society. We believe that the study of the law should never lose sight of the social problems that law exists to deal with, and that lawyers should always be ready to criticise and reform the law. We believe that a law school should not exist in an ivory tower. Staff and students should build and maintain contacts with the practising profession and with the real world in which lawyers work. On the other hand, the law school should be a good vantage point from which to stand off and look at the law and the profession with a detachment the practitioner can seldom enjoy." This lecture was established in 2006 to honour Hal Wooten's life as one that was lived greatly in the law by inviting others who have also done so to share their reflections on this theme. And tonight's speaker is an ideal choice, not just against that criterion, but also in light of the words I've just read to you that encapsulate a central plank of Hal's vision for the faculty and one that guides our work still. Our speaker tonight has never lost sight of what law exists to do in society and has been well placed to point out when the law falls short or fails to protect those who most need it. And he has done so moving between the worlds of practice, academia and the bench. In introducing David Heilpern as tonight's guest speaker, I have the job of giving just enough information so that you are aware of who he is and what is to come, but without any spoilers as to the themes on which he might elaborate. So here's a very thumbnail précis for those of you who don't already know. David was appointed as a magistrate in 1998 and was at that time the youngest magistrate in Australia. He sat in the criminal, mining, family, industrial, coronial and children's jurisdictions of the local court and later served as the senior civil magistrate in New South Wales for 5 years. Prior to his appointment, David was a lawyer on the North Coast, where he co-founded the first non-metropolitan law school in Australia at Southern Cross University in 1992. And David maintained his litigation practice through that period. He's an expert on victims' rights, prison reform, drug law reform, Aboriginal overrepresentation in the criminal justice system, and environmental activism. He retired from the magistracy in 2020, and in August 2022, he returned to Southern Cross University as the Dean of Law. So that's the basic outline, but much more is conveyed always by looking at how rather than what. And to that end, I thought I'd supplement the details by quoting from the tribute written by Stephen Lawrence and Jeremy Stiles in the New South Wales Bar News upon David's retirement as a magistrate. And amongst other things, the authors said, scrupulously proper, careful but often bold, David Heilpern was never likely to be a darling of the New South Wales Police or radio shock jocks. His judicial humanity was clear from the beginning to the end. He favoured the powerless to the extent the law allowed. On the bench, Magistrate Heilpern was assuredly self-assured. He was direct. He could be unforgiving. He had an abiding intellectual engagement with both statute and common law. His judgments were frequently befitting of a more ponderous jurisdiction. In engaging with an intellectually difficult point, his eyes would alight. In 2017, Magistrate Heilpern broke the judicial fourth wall and talked openly about the self. He provided leadership by revealing his struggle with vicarious trauma. It is a measure of his integrity and intelligence that his public legal personality reflected his private beliefs to the extent that the office would allow. The authors concluded, "We have learnt from him. The profession should wish him well in his retirement." David is clearly one of those people, not unlike the namesake of tonight's lecture, for whom retirement from one role is but an opportunity to acquire another. I thank him for accepting our invitation to share his experiences and insights tonight, and know that we also can look forward to learning much from him as he delivers the 2024 Hal Wootten Lecture. Please join me in welcoming David Heilpern.
Thank you. Thank you very much. It is indeed a great honour and privilege to be able to deliver the Hal Wootten Lecture for 2024. I've prepared a written paper as an adjunct, but I don't intend to read it. Law is inherently exciting and interesting, but not when read. The oral tradition is one of stories, not content. I met Hal Wootten only once, and I called him Professor, and he corrected me and said, "Just call me Hal." So for the purpose of this lecture, I will. When I spoke to my father, Hans Heilpern, and told him of this invitation, I said I was surprised and thought that they'd made a mistake. He agreed and said that he was surprised and that they did make a mistake because the invitation was meant for him. Funnily enough, I then spoke to my uncle, Hal Sperling, who's here, himself a contemporary of Hal Wootten, perhaps the only two Hals in the law, and he had exactly the same response. Until now, the highlight of my career was written on the toilet wall on the main street of Nimbin. "Need a lawyer? Call me." Sometime in the 1980s, that got changed to "Need a poet." And I actually thought at that point I'd reached my career zenith. Shortly afterwards, it said "Need a magistrate? Call." This led to some highly compromising conversations, but I didn't change my number. I just told them they really needed to wait for court. Most recently, I went to Nimbin and it had been changed to "Need a law degree? Call David." This is the entirety of my career in a nutshell on the toilet wall at Nimbin, and I'm so deeply proud of it. Hal has described the lecture series in his honour as an opportunity for the speaker to talk about their life in the law and to reflect on the obligations and responsibilities we have as lawyers, how they've used this to shape society where social justice is held dear. I will do this, but only for half the time. For the rest, I really want to speak of the theme of a week here at UNSW, imagining the future. I want to address some specific areas of law reform that reflect my aspirations for the future, which is one characterised by nimble legislative change. So part one, my life in the law. As I read the life story of Hal Wootten, I realised that our life paths and interests were remarkably similar. I was actually imagining the old-fashioned scoring for the Olympic Games diving, where they hold up a mark out of 10 as I compared our calling. Hal universally got a 10. I somewhere between 5 and 8. Just a bit too much splash, it seems. Hal and I share a passion for the cause of Aboriginal rights and outrage at the overrepresentation of First Nations people in our criminal justice system. Hal, of course, gets a 10 because he helped establish the Aboriginal Legal Service, for whom I worked in Kyogle and in Redfern. He went on to be a commissioner at the Aboriginal Deaths in Custody Royal Commission and a member of the Native Title Tribunal. I was motivated to join the magistracy largely to seek to address this cause. I succeeded in a couple of areas. Firstly, I decided that the word fuck was no longer offensive. This led to a mass reduction in offensive language charges in the local court, something which has lasted to this day. I perhaps should have given a trigger warning. There will be much swearing in this lecture. Secondly, I attacked the trifecta, the arrest for offensive language, resist arrest and assault police in Carr's case, and both the offensive language decision and Carr's case have stood the tests of time. However, despite Hal's efforts and mine, the gross overrepresentation continues and grows unabated, and Aboriginal people are, much to my shame, the most imprisoned race in the world. The Uluru Statement from the Heart mentioned only one closing the gap issue: incarceration. Proportionately, we are the most incarcerated people on the planet. We are not innately a criminal people. Our children are alienated from their families at unprecedented rates. This cannot be because we have no love for them, and our youth languish in detention in obscene numbers. They should be our hope for the future. There are still hanging points in New South Wales cells, despite Hal's findings. Some detention centres are 100% Aboriginal kids. Racism abounds throughout our police forces still. I cannot rest easy and enjoy any sort of retirement while such injustice exists, and neither could Hal. As Hal wrote, he had a short fuse in the face of injustice. Michael McHugh, in this lecture, noted that Hal was obsessed by a desire to see justice for all. Chief Justice Kiefel said he tried to be a nudger of the law. That's a slight underestimate. I don't think Hal and I nudge. We push, we bulldoze. I'm not sure if it's a curse or a blessing, this shared inability to accept inequity. But I can say it hurts. Physically and mentally, it hurts. And I'm more driven than ever to respond. It is within that context that I wish to belatedly acknowledge country. One day I was sitting at Brewarrina local court, and we'd flown in by plane with the police prosecutor and the court staff and legal aid. And the registrar, when we arrived at Brewarrina, told me that unfortunately there was no transport for young people and I could not refuse any young people bail. Alas, there was a young person who had evidently committed a series of serious crimes in breach of other bail, and I had to refuse him bail, and I did. Lo and behold, when I went to get on the plane again, there he was, locked onto the, handcuffed onto the handrail with a police officer behind him and in front, and I was sitting in the aisle opposite. Now, I neglected to say that Brewarrina is the home of the oldest remaining human structure in the world, which are the Brewarrina fish traps. So as the plane taxied, he, the young man, we acknowledged each other and said g'day, and the young man started shaking and sweating. And I said to him, have you ever been in a plane before? And he said, no, and I've never been out of Bree either. So there we were taxiing along, and the plane started taking off, and he started gagging and vomiting. And so I grabbed my sick bag and held it for him. And as many here will know, I can't cope with that sort of bodily fluid. So I just looked out the window as the plane was taking off, and I freeze-framed that scene in my mind. There is an Aboriginal man removed from his country, being taken to Dubbo to be locked up. And there I am, a magistrate, 250 years of legal history, looking out at the oldest human structure in the world. And that, to me, summed up everything that was wrong with the criminal justice system. So with feeling, I would like to show my respects in the light of that story and acknowledge the Bedegal people who are the traditional custodians of the land on which this discussion takes place, to elders past and present. Hal was a QC at 44, and I never became a QC, SC or KC. I did often get called a different kind of C. And on one memorable occasion, I refused someone bail in Wellington, and as he was being led away, he called me a fat C. I had him brought back to the dock and said, "Did you call me fat?" Hal, of course, was a judicial officer, and he gets a 9 on the scorecard for the Supreme Court. I give myself a healthy 8 for the local court, and I'm honoured to be the first magistrate to give this lecture. I was very young, and there I am on my first day at Dubbo local court. Can you imagine the poor people thinking, I've got a child about to determine my future? But when I was first a magistrate, an unnamed Chief Justice of the Supreme Court was invited to speak to our annual conference dinner. At that time, and it's no secret, magistrates generally can't stand Supreme Court judges, not because of what they do, but because of what they have. Money, wigs, tip staff, associates, and the best superannuation in the world. But jealousy is like drinking poison and expecting someone else to get sick. So we invited the Chief Justice to speak to our annual conference. And Chief Justice Spiegelman came, and reading the room perfectly, he told us this story. So I'm being him now. On the day of my appointment, I was dancing around the living room saying, "I, James Spiegelman, I am Chief Justice of the Supreme Court of New South Wales." I was looking in the mirror, smiling smugly. My wife, ever alert to any hint of egotism, suggested nicely that I go for a drive. I got in my brand new Chief Justice mobile, a Holden Statesman, and, I'm adding this bit, perched upon a cushion, I drove around for a while, playing with the buttons and gadgets I'd not seen before. So focused was I on the stereo system that bang, I drove straight into the back of a truck. The truck driver got out of the truck, all blue singlet, aggro and Chook Fowler shorts, and I pressed the magic button for the window to come down. "Who do you think you are?" he asked. I said, "I am Chief Justice James Spiegelman of the Supreme Court." And he said, "I wouldn't give a fuck if you were a magistrate." Which illustrates accurately that for most people, magistrates are the law. They're the beginning and the end of it. And so it was a great pride to sit, with great pride that I sat on the local court. I was delighted to read that Hal, like me, joined the Communist Party when he was young. He described it as, quote, very boring and dissent was unimaginable. I too did a stint with the doctrinaire and I learnt the difference between Spartacists, Trotskyites, Maoists, Stalinists, Leninists and the one true party. It was the same year that the movie The Life of Brian came out. And I'm sure that some of you will recollect this scene about the People's Front of Judea, or is it the Judea People's Front? And that's what it was like being in the Communist Party in the early 1980s in Sydney. Like Hal, we both lost faith and left. Hal and I both had and have a lifelong love of the people of Papua New Guinea, and indeed, when I met him, we spoke Pidgin together. I first visited Papua New Guinea in 1979, and then later, with my colleague, Magistrate Ian Guy, we trained magistrates in Papua New Guinea for 15 years. Hal describes it thus: PNG taught me the power of humiliation, its ubiquitous and corrosive effect where one group of people believe they are superior to another. I too learnt lessons there, and in particular one from Justice Sagu, who at the time I met her was the president of the Children's Court in Port Moresby. We were sitting at a table and I said to her, how many children do you have, as you do? And she said, well, I've got 4 plus 10. And I thought that was a pretty heroic effort. And I said, how come 4 plus 10? And she said, well, I've got 4 of my own. But if I have to refuse bail, or if they've got nowhere to go, or they can't go back to their village, then I bring them home with me. And once I got to 10, my husband said, stop, that's enough. So then I had to wait for one to, turn 18 or go back to their village or get a job and leave home. But that's why we've got 4 plus 10. That was a revelation to me and changed utterly my views about the role of judiciary in the community. Because why not? Why not be a part of the community as opposed to so completely separate from it? Hal, like me, helped start a law school, and this is Southern Cross Uni Law School in 1992. For Hal, he saw a need to teach the law differently and approach the law differently. For me, it was that my colleagues and I saw that rural and regional people were really disadvantaged by having to travel to Sydney to study law, and hence we started Southern Cross University Law School, and I'm so proud of the law school that we started. It took Hal no time to become dean. Indeed, he was dean immediately, and it took me 30 years, so the scorecard continues, but we both got there in the end. Hal Wootten was deeply concerned about the mental health of legal practitioners. He wrote, "There is no lack of evidence of the agonies suffered in wrestling with the choice of such a profession. For long, it was a literature of personal anecdote and rhetorical affirmation. The challenge for me," he wrote, "was an intensely personal matter to be resolved within me. There were no counsellors or mentors or kindly souls to manipulate my learning or work environment. As so often in my life, I turned to other men's words, taking comfort in William Henley's Invictus. Out of the night that covers me, black as the pit from pole to pole, I thank whatever gods may be for my unconquerable soul." Hal was ahead of his time in this cause, and my own battles with vicarious trauma are well documented. Speaking out about this while still serving as a judicial officer was incredibly difficult, but in retrospect, the proudest moment of my career. The support I engendered from my colleagues on the bench and in the broader profession was simply extraordinary. I was recently asked at a leadership group, is there something that you wish you'd known when you started your career that you now know? And there was. It is this, that to show vulnerability is not a sign of weakness, it's a sign of strength, because it brings out the best in others. Hal was deeply concerned about environmental matters, and so have I been. Hal gets his customary score of 10 as President of the Australian Conservation Foundation and as patron of the Environmental Defender's Office. He proudly loved getting into the bush, and when I met him, he told me a long and nauseating story about getting a leech in his eye for 36 hours. I helped form Lawyers for Forests, and gratefully now have the opportunity to continue to provide legal advice to those engaged in direct action to save the environment. I fundamentally believe in non-violent direct action, in breaking the law to make the law. At least two of the previous speakers have spoken of this, Jennifer Robinson and, of course, Albie Sachs. There is a time when inaction in the face of grave injustice is not an alternative. I recently spied Bob Brown when we were both at the Byron Writers Festival recently. He's written a children's book and he was speaking to a group of children, and he said to them, one of them asked him what was it like having to go to prison, and he said, "I loved going to prison. I got to read and meet some lovely people." What a great message for our children. Hal also showed an ongoing commitment to and support for Palestinian lawyers, law students and law schools. He lived in the West Bank for 3 months, and he was detained by the Israeli authorities when supporting those who regularly went to protect local farmers from Israeli settler violence. At 92, he enrolled in Arab studies as an undergraduate. One of his few regrets was that he was unable to sufficiently support scholarships and fellowships to students and staff of the law schools of Nablus and Jenin that I got to know during my recent 3 months on the West Bank, men and women who are isolated by the checkpoints and travel controls of the occupation, yet aspire to help build in Palestine a liberal democratic state. Well, I share his hope and his vision that one day we will have Palestinian law students here. Finally, in part one, Hal was born in my hood, the north coast of New South Wales, not 3 kilometres from where I now live, and he kept a lifelong interest and love of the land. I share that vision. So now to part two. You can have a little breath now if you need to, perhaps a small stretch. Changing the law. When I was here at law school, at UNSW and then at Macquarie and then ANU and then, does study ever end? I shared a hopeful but simplistic view that the slow erosion of the common law, of judge-made law, was a good thing, and that codification was superior to the inflexibility and fuddy-duddiness of judge-made law. Imagining the future then, I saw a nimble and flexible statutory regime as the ideal model for law reform. But in many ways this has proven to be a forlorn hope. Perhaps due to Hal's well-known disdain for the Murdoch press and its influence on parliamentarians, whatever the reasons, I want to spend the rest of this speech focusing on some rapid, simple areas of change that could make a difference. I've chosen 3 areas: remand rates, victims' rights, and drug law. For each, I'll outline some simple, non-controversial, hopefully, law reforms. The situation with respect to remand in Australia is utterly shameful, an indictment of our criminal justice system. The words innocent until proven guilty mean nothing when 42% of those in custody in New South Wales are actually only bail refused and not convicted. Worse still, for young people under the age of 18, that is 60% of all of those detained are innocent in the sense that they've not been convicted of any crime. So resource allocation is such that young people fare worse under the remand system than adults. And let's make no mistake, every time the bail laws are tightened, there's really only one group that is affected. The remand rate for Aboriginal adults has gone up 47% in the last 5 years. For non-Aboriginal people, it has increased only 2%. So all of the rah-rah about tightening bail laws actually only principally affects one tiny portion of the population, that is the Aboriginal population. Refusal of bail is like an insatiable beast. It reminds me of visiting the USA in the 1990s, where they had do drugs, do time. Then there was everyone in possession of drugs was sentenced to 5 years imprisonment, minimum mandatory term. And yet the tabloids were calling for tougher penalties because the drug problem was out of control. Those of you who've seen a recently released movie called Unlikely Allies will also know that that case deals with a person who sold less than $1,000 worth of cannabis and was jailed for 55 years with no prior convictions. So sentencing, like bail, is an insatiable beast, unable to ever be satisfied because it doesn't achieve its aims. It's not actually, bail reform should not be about locking up more people. It should be about locking up the right people. And that takes time to assess. So what's a solution to this problem? Well, partly, I think this is capable of remedy. And a story will illustrate exactly how. If I was sitting in Lismore, on a Monday, I would have 100 matters before me and about 5 to 10 people refuse bail, seeking bail. So I would have, on average, somewhere between 3 and 5 minutes to deal with each bail application. If they were bail refused, that could be for months or even years while they were awaiting the outcome of their hearing. If they wanted to appeal or review my decision, it has to go to the Supreme Court, which of course sits only in Sydney and costs a lot of money and involves family and friends trying to get down there to provide support to the family member who is seeking bail. Yet, sitting right next to me every single workday is the District Court, a higher court. And for reasons lost to the sands of time, bail appeals only can go to the Supreme Court, not just here, but in every state that has 3 tiers. This is an incredibly inefficient method of sorting out bail because in the 3 to 5 minutes, I can get it wrong and did get it wrong. Most magistrates have terrible stories of where they have released people on bail who have then killed or refused people bail when they were then killed in custody. So these are really important decisions, yet the review is only by the highest court in the state. Why can't it go to the District Court? There they are sitting next to me with breaks because juries are out, because short matters fall over, and yet the District Court can't hear a bail review. Of course, there is some resource implications for this. In other words, the District Court would have a bit more work. But the bail list in the Supreme Court would completely disappear. And thus, those resources should be reallocated to the local court. And I think if we do that, we would have more of the right people granted bail and the right people refused bail, and thus lessen the numbers of people on remand. This should be a priority and shouldn't be controversial. Like, who really cares whether it's the Supreme Court or the District Court who makes a decision on bail? And imagine the local family can have their family there for the bail review. The local DPP, who will eventually be dealing with the appeal, can be there. It's win-win. I want to now move to victims' rights, and I would like to start with the Victorian case of Johnson. Again, there's a real trigger warning for this. It's an awful case. In December, and the reason I've chosen this case is not because it's unusual, but sadly because it's typical. And I'd ask you to reflect, I'll be talking about 3 cases, each of which involve victims of sexual assault. And when the cumulative effect of these 3 decisions, I'd like you to reflect on the consequences of this in terms of where we are now with victims' rights in Australia. In December 2020, the police entered a property in Melbourne owned by a person called Johnson. They had a warrant to enter those premises to search for a child. It quickly, after 10 minutes or so, they received information that that child was in fact 10 kilometres away. So what they should have done was abandon the search and leave. But they didn't, because their suspicion was raised, and they located a video which depicted Johnson sexually abusing a drugged, comatose person. They left the premises after viewing this and went and got a search warrant and came back and seized this property. They then interviewed Johnson's partner, who identified her ex-partner, who identified herself as the person involved, and that she had had absolutely no idea she had ever been drugged or sexually assaulted. So he was charged with 4 counts of aggravated sexual assault, and she'd had an AVO out on him at the time, so he was also charged with that. This is a serious crime. The district court judge, the county court judge, a female judge, was confronted with the argument, well, this evidence was illegally obtained. That is, the police should not have searched for an additional half an hour and sought and obtained this video material. She decided that when doing a balancing act, as is required under the Evidence Act and under the old Bunning and Cross rules, that this was, that easily the admission of the evidence outweighed its exclusion. The defendant appealed, and it went before 3 male judges of the Court of Criminal Appeal in Victoria, who decided that the police action was so heinous, quote, this was a deliberate, continuous, invasive and totally inappropriate search of private property in the absence of the owner and occupier without lawful excuse. They excluded all evidence, and accordingly, the rape charges were all dismissed. Not once in their judgment is there any mention of the word victim. That judgment, in my view, when analysed, represents a triumph of legalism over modern community values, of property rights over personal rights, of a defendant's privacy over a victim's justice. In my view, that decision is wrong on legal, discretionary and principle grounds. But even if it's sustainable or arguable at law, then the law ought be changed. It ought recognise the victim's rights in those circumstances, specifically including that the court must consider the victim's rights before excluding evidence. I mean, how is the victim meant to feel about this result? The police exceeding their authority, perhaps for half an hour, leads to a circumstance where her ability to have justice and all of our ability to find justice is lost and permanently lost. The court was obsessed with the fact that the police could be disciplined for this and hadn't been. Well, you know, those of us who have ever looked at police disciplining police or any external authorities will say, well, that is a bizarre criteria for assessing whether evidence should be admitted or not, and that the rights of victims should replace it. The second case I wish to deal with is that of Bruce Lerman. Imagine that a rape complainant, awful word, let's just use the word victim, goes to the police station seeking to report a rape. She's handed a card that says, please note, if you report this rape, then the defence or police may obtain court orders that you surrender all your electronic devices, every email, Facebook post, SMS or other social media activity. The defendant will personally be able to see all of that material. And not only that, but if it ends up on the front page of the newspaper, for example, The Australian, even material never used in the trial, then there's nothing you can do about it because the journalist will not disclose their source. How many women would report the crime in those circumstances? How many people would report that crime in the circumstances? That nothing has been done to change this is the current status of the law. That is the warning that victims need to get, because everything, and I've heard it described recently as digital strip searching, all your records can go to the defendant. And we've seen the results of that in the Bruce Lerman case. a nimble legislature would simply pass a law that says any material that can reasonably be suspected of having been obtained as a result of a court order to produce may not be published, except with the consent of the court. Now that would protect those. And I ask you to think about this. I mean, this to me has set back the rights of complainants, victims of sexual assault matters decades. All the other reforms we've seen, closed courts, not able to ask victims about their prior sexual history and the like. This challenges all of that in terms of the ability to report crime. The third area of victims' rights involves sentencing, or rather the inadequacy of sentencing. In the case of Boyd Kramer, a New South Wales case, the victim was raped on the 20th of December 2020. Kramer had pleaded not guilty. The victim had been cross-examined by Margaret Caneen for days. The jury found him guilty. Judge John North, despite the plea of not guilty, sentenced him to a community corrections order for a period of 2 years, with some community service. That sentence is what you get for a second shoplift. It's actually what you get for an altercation at a pub. The maximum penalty is 14 years. The standard non-parole period, which is the standard sentence, is 7 years imprisonment. Yet he walked away after pleading not guilty under full trial with a good behaviour bond and some community service work. Now, the Court of Criminal Appeal rightly found that that was manifestly inadequate. That means they found that the sentence was blatantly and obviously deficient. Of course it was. However, despite this finding, the Court of Criminal Appeal decided not to interfere with the sentence because there's this other judge-made proviso where the prosecution must prove that the court nevertheless should not interfere. So what that means is that sentence stood. This residual discretion with the onus on the prosecution is archaic and, in my view, has no place in modern sentencing. If sentences are manifestly inadequate, then they're inadequate and they should be made adequate. But simply relying on a proviso such as that means that there is no justice. I mean, how is that victim meant to feel? And you can Google 60 Minutes and watch how she does feel, because she's interviewed, and so am I, talking about the impact that it had that he received this penalty that was manifestly inadequate for this crime. A nimble legislature would simply respond by passing laws that rid us of this additional proviso. If it's inadequate, then that should be sufficient. So the three stories that I've told about and cases that I've mentioned about victims' rights paint an overall picture, in my view, that requires parliamentary urgent intervention. Drug law. This sums up my position precisely. I mean, really, in giving evidence, I think the 14th inquiry I've given evidence to on drug law, I commented on how in the past, in my early days, I had represented abortionists, prostitutes, SP bookmakers, vagrants, homosexuals, blasphemers, and all of these are decriminalised or legalised or otherwise regulated. All of them, except drugs. No one rationally suggests winding back the clock on all of those rules. Well, I did say that when I wrote it, but of course, on abortion, I think we may need to put that in a separate category after South Australia and perhaps Queensland, but we'll wait and see. But drug law reform is stuck in the 1950s, with all the waste of police, court, legal profession, prison resources, all in an effort to deal with what is at worst a victimless health problem and at best harmless experimentation. I just want to concentrate on two areas: mushrooms and drug driving. There's a couple of legal concepts I just want to introduce some of you to. They're not highly technical. The first one is show cause. This means that if you are in a possession of a certain amount of mushroom or any drug, then there's a presumption effectively that you won't get bail, or it's going to be a lot more difficult. The second is deemed supply, which means if you're in possession of a certain amount of a drug, you are deemed to be a supplier of that drug unless you prove otherwise. And the third concept is admixture, which means it's not the potency of the drug, it's the whole of the item. So even though psilocybin may make up a tiny part of a mushroom, it's the whole mushroom that's considered. Now, when you add these concepts together, the result with mushrooms is bizarre, because the deeming amount, that is the amount of which you are deemed to be a supplier, is 0.15 of a gram. I weighed a mushroom from Coles, from Woolworths at Byron Bay, and it was 111 grams. The difference between that and 0.15 of a gram, I think you'll get. Worse still, the amount that triggers a bail refusal presumption is 25 grams. So some poor, experimentation-seeking person goes and picks a magic mushroom out in a paddock, and they are a deemed supplier and they are refused bail. Now that may seem like theoretical to you, but it's not for several hundred Australians every year who end up in exactly this position. And again, it's simple to change it, and that is to change it just like the Commonwealth law, that it's the strength, it's the essence of the drug that's the problem, not the whole of the mushroom, or simply regulate it in a much more sensible way. So hopefully that will be changed, but let's not hold our breath. I don't think the Drug Summit is going to be concerned with changing mushroom laws. The second area is drug driving. I am so bored with speaking about this, and I know that my family are very bored about listening to it, let alone all of my friends. What can I say that has not already been said so lucidly and convincingly by me already? The stats tell the picture. I mean, medical cannabis driving in Australia, there are now 1 million prescriptions. There are 250,000 tests done in New South Wales alone, random drug side road saliva tests. That is more than the rest of the world combined. Nobody else does this. And I think it is one of the most massive criminalisations of the Australian population, that it is the most that I have ever seen. There's at least 350,000 in New South Wales alone who use medicinal cannabis, and every one of them is committing a crime if they drive. There is not one iota of evidence that prescription cannabis users have led to a single death on our roads or have increased road trauma in any way. This current status quo is maintained by a group, by alcohol companies, by the police who oppose any change, and by a group of roadside safety experts, in inverted commas, who deliberately confuse causation with correlation, and who deliberately suggest that those who use prescription cannabis are a danger on the roads, despite no evidence to that effect. Of course, we don't have these rules for any other prescription drug. We don't have it for benzodiazepines, we don't have it, not even for mushrooms. We don't have it for opioids, we don't have it for any of the drugs that we all know can cause impact on the road, but we do for prescription cannabis. And not only that, but those who are driving with cannabis in their system because they have it prescribed are also driving around, in many cases, completely uninsured. This is the AMI policy. You are not covered under any section of this policy for anything that is caused by or arises from an incident when your car is being driven by anyone who had more than the legal limit for drugs in their saliva, What's the legal limit for cannabis? THC, 0. So anyone who goes to their doctor, hundreds of thousands of Australians who go to their doctors and get a prescription are not covered under their insurance policy. So, just change the drug laws. It's not, and just change the drug driving laws, and hopefully I'm going to the drug summit in Lismore on Monday, and I'll be saying that, and well, we'll see what the outcome is. My favourite to finish up, and you've been very patient, my favourite Hal Wootten quote is this: "My career has been built on my inability to say no when invited to do something I was not qualified to do." This rings so true for me. Imagine making me a magistrate or a dean, let alone saying yes to this lecture. My second favourite quote, which is the way Hal finished his lecture in this series named after him, is, "Don't let the bastards get you down, and don't forget about climate change." That is my message as well. So, thank you to the University of New South Wales who've been such gracious hosts for me. Thank you to Hal's family, Gillian, for inviting me. Greatly appreciated, and thank you to each of you for listening and for coming. Many thanks. How was that? Boring?
How good was that? Not surprising, I've got to say. I've been looking forward to this for a long time. Okay, let me begin by acknowledging the Bidjigal people and all our Aboriginal friends, students and colleagues who are here tonight. I might just, I don't know if I can say the thing that you sent a message around about earlier today, Andrew. Andrew just sent us an email earlier today with the great news that one of our students, Corrie Blythe, has just been awarded a scholarship to study at Oxford University, a Rhodes Scholarship. So this is the first Aboriginal student that we've had who has got one of those wonderful scholarships. So I think that just shows the commitment of this place to our Aboriginal students. It's great to see so many friends here tonight. Particularly, I acknowledge Julian Coleshaw and Michael Kirby and the friends from the Law Advisory Committee. Doing this close-up, I'm very aware of stepping into big shoes. The vote of thanks is usually a kind of perfunctory thing. It's like, yes, very good, come on, let's get upstairs and have a drink quickly. But Hal Wootten made this in some ways, the most anticipated part of the Hal Wootten Lectures, because he always did it. And that was not least when the speaker, as occasionally happened, didn't quite live up to expectations. But I didn't need to worry tonight, because on this occasion, David Heilpern has given us a lecture that Hal, I know, would have loved, addressing the themes of this series in such great style and humour as well, which Hal would have loved. When Hal and I started this series back in 2006, we saw it as serving two purposes, as really Andrew has mentioned. The first one was, in Hal's words, to commemorate the founding vision of this law school. I don't like the word commemorate. It sounds to me appropriate for something that you would hang a wreath on. I prefer celebrate. And one celebration of this law school will be a chapter in a book of Hal's essays, which Andrew Lynch and I have been working on, and which we deliver to the publisher tomorrow, with the enormous help of a wonderful current UNSW student sitting over there, Oscar Idell. So this is a great way of looking back to see what this place was all about in the heady days of the early 1970s. I must admit that 4 or 5 years ago, I might have thought that maybe commemorate was the more appropriate word, because COVID had disrupted just so much of what defines this law school. I was teaching first year after I finished as dean, I learned that you can teach well online, but it doesn't allow for the kind of teaching and the things that go with it, the broader interactions between academics and students and all the other activities, even down to the most basic thing, like for a student going to writing a court report for crim law. All of that had to be suspended, and you wondered how the old law school would ever come back. However, I've been really delighted to see the faculty's renewal in the last year or so. It confirms the strength and adaptability of that vision and of the institutional culture of this place. My colleagues have just finished a new strategy, the Law and Justice 2030, which is on the faculty website, and I really recommend you having a look at it. It recommits to fundamental values and principles and looks ahead. Now, frankly, I've never been a great fan of big strategic plans and all that kind of guff that goes with them, but this one I like. To just give you one example, it puts in the center of the strategy the commitment of the Law and Justice faculty to the centers which are based here but which are not formally part of the university, what we call the affiliated centers. And these are the organizations like the Diplomacy Training Program, Youth Justice Australia, Pro Bono, Migrant Justice, Grata, and RACS. When I was dean, my priority too often was defending these organizations from Chancery bean counters who couldn't understand why we weren't charging them rent. Now they are really pulled into the center of the work of the faculty. The second aim that we had with these lectures was to ask speakers to tell us how, in the words of the great American jurist Oliver Wendell Holmes, they have made a life in the law. In his own lecture in 2008, Hal told the story of how he found it possible to live greatly in the law. Again, it's a chapter in the new book. David Heilpern has addressed himself to that challenge, finding numerous parallels in such a wonderful way in his own lecture between Hal's life and his own. Founding a law school is one of them, although Hal's self-deprecatory line about doing things you're not qualified for, I've got to tell you, it's actually not quite true. Hal had a very long interest in legal education. He spent a lot of time when he was running Law Asia working on legal education reform in our region, and he'd done a lot of work with PNG. But his interest went back further, and this is the point of the story. When he was a student at Sydney University in the 1940s, he drafted an alternative curriculum for Sydney Law School. Sadly, that document seems not to have survived, but I would love to have seen that. In the second half of his lecture, David gave us some great examples of areas of the law which need the attention of a nudger. And maybe I could just explain a bit more why he talked about nudging. He meant it deliberately, that idea of just starting things going, and then it turns into the big push. Hal developed a fine method for a person who wants to contribute to the world. It's nothing complicated at all. The main thing is, don't just talk about stuff. He hated people sitting around just going, blah, blah, yes, it's terrible, isn't it awful, yes. His line was, talk about it, inform yourself, plan, and act. And he did that in so many areas with such great success. The finest example for me is the outcome of the concern about the Middle East, which led a man in his mid-80s, as David Heilpern mentioned this, to travel to Palestine to spend months talking to Israelis and Palestinians, and then deciding that what we could, as a law school, could best do is to contribute to strengthening the leadership of the Palestinian people by bringing students here to study and to learn ideas about justice, the rule of law, and a working democracy. He came back from Palestine, went to Canberra, and used his, the only thing he really used those AC and QC baggage for, to get his way into rooms to talk the bureaucrats and the ministers into funding this scheme. And so I think, David, just maybe you didn't quite get the message about this, that wasn't just a plan, it happened. And now, just over 10 years ago, we had a group of Palestinian PhD students who were here working in the faculty and completing their PhDs, and who have now gone back to Palestine and are working in various organizations, including law schools. One of the one that I personally supervised with Janet Chan, working in the security sector. And I'd add to that when they were here, one of the great things about that program was that my colleagues all threw their weight into it. And these were hard students to supervise, I've got to say. It took a lot of work. But there was so much goodwill towards this group. And not just, sorry, start again. It was across the board. A number of our Jewish colleagues were involved in the supervising of those students and developed great friendships with those Palestinians. It's such a good story, frankly. On Palestine, the only limit to my regret about Hal's death is that I'm glad that he didn't live to see what has happened there, or to see how pitiful and shameful our government's response has been to what is being done. David Heilpern's examples are classic nudges of the kind that Hal would have loved. I loved hearing about, particularly about the procedural reform which would reduce Aboriginal imprisonment by allowing appeals against bail refusals to go to the district court rather than to the Supreme Court. It shows just how entrenched conservatism is in the law. When I talked to a guy I know who's a criminal lawyer about David's proposal, I was just interested to hear what he thought. He said, no, I don't think so. It's appropriate for more senior judges to deal with a matter such as that. Oh, good. And this is a man who does a lot of criminal law. So I asked him, so how often do you then take appeals against bail refusals to the Supreme Court? Oh, no, I've never done that. It's that kind of complacency which I think would have infuriated Hal, as I suspect it will David. The nudges for which David Heilpern has become a legend amongst UNSW criminal law teachers and students are mentioned in the first part of his paper, particularly the Dunn case from Dubbo in 2009, in which he refused to convict the young Aboriginal man for the offence of saying the words "fuck off" to a police officer. I want to just push into that a bit more. What's really important about a decision like that? A magistrate saying, hold on, saying the emperor has no clothes here, this is just ridiculous. It's important because it takes seriously the Royal Commission into Aboriginal Deaths in Custody insistence that we have to stop sending people to jail, whether on remand or sentenced for such trivial offences, with the result that they multiply Aboriginal imprisonment. It also, that kind of approach shows that the law has to be applied and interpreted in the magistrates' court and taken seriously as law, just as much as it does in the equity division of the Supreme Court. It breaks the old practice of subservience to the police, which I remember, again, back to my time teaching criminal law, that our criminal law book quotes a great example of a Chief Justice berating a lawyer for daring to challenge the reputation of some police officers by saying that they were lying in their evidence. Unfortunately for that Chief Justice, it was Chief Justice Street, those officers were Roger Rogerson and his merry men in the armed hold-up squad. Now, I'm not suggesting that David was alone in doing these kind of nudges, and I'm sure that he wouldn't do so, but he played a leading part in making an unappreciated change in the way our magistrates do their work. And that work is, as he said, the most important part of the criminal jurisdiction and civil jurisdiction too. They deal with many civil cases. So I hope that you'll agree with me that David Heilpern lives, because I'm damn sure that he's not finished yet, greatly in the law. And before you come to join us for a drink and to continue the discussion upstairs after the lecture, that you will join me in thanking David for a fine Hal Wootten lecture. Thank you.